Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is Thursday. At a little time before testimony resumes in the Robert Tellis trial later this afternoon. And I wanted to update on some new filings in the Ashley Benefield trial, as well as the South Carolina Supreme Court's decision to hear arguments from Murdaugh about why he deserves a new trial. We're going to jump in, but first, if you're watching on YouTube, you know the drill by now, don't you? Don't forget to hit subscribe if you haven't already. Like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Just click that little bell icon. Music fact of the day. What other huge pop star was originally considered for the lead role in The Bodyguard? That would be Madonna. Ashley Benefield's lawyers have filed a couple of pretty big motions. The first one we're going to talk about is a motion for judgment of acquittal. This filing is over 20 pages long. I'm not going to get into the bulk of it. A lot of it is the backstory, Ashley's version of events of what happened that night, and then they cite a good bit of case law for their argument. But the conclusion says, number one, insufficiency of circumstantial evidence, as established in Diaz versus State and reiterated in State versus Law, where the only proof of guilt is circumstantial, a conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. The state's purely circumstantial case fails to meet the standard, and it is entirely consistent with Ms. Benefield's claim of self-defense. Number two, lack of contradictory evidence. The state has presented no direct evidence or testimony that contradicts Ms. Benefield's account of the events. I'm going to butcher this name, but I'm going to give it a shot. As held in Bueno Ano versus State, the jury can only disbelieve the defense regarding facts on which the state has presented contrary testimony. Here, no such contrary testimony exists in the critical elements of Ms. Benefield's self-defense claim. Number three, failure to rebut prima facie case of self-defense. As established in Jenkins versus State, once a defendant makes a prima facie showing of self-defense, the state bears the burden of disproving it beyond a reasonable doubt. Ms. Benefield has clearly established such a prima facie case, and the state has failed to present any evidence that would disprove her claim beyond a reasonable doubt. Number four, absence of physical or forensic evidence. There is no physical or forensic evidence that rebuts, contradicts, or impeaches Ms. Benefield's direct testimony. Number five, threshold determination. As articulated in Fowler versus State, it is the court's duty to determine as a threshold matter whether the state has produced competent, substantial evidence to contradict the defendant's story. If the state fails in this initial burden, the court must grant a judgment of acquittal. In this case, the state has clearly failed to meet its initial burden. Number six, insufficiency even in light most favorable to state. Even when admitting all facts and evidence and every conclusion favorable to the state, the evidence remains wholly insufficient to support a guilty verdict. No fair and reasonable inference from the presented facts can exclude the possibility of self-defense. In light of these principles and the nature of the evidence presented, it is not only appropriate but imperative that this court grant Ms. Benefield's motion for judgment of acquittal. Allowing this case to proceed to the jury ignored the clear standards set forth in Florida case law and resulted in a conviction based not on evidence, but on mere suspicion, conjecture, or prosecutor misconduct. The version of events related by the defense must be believed if the circumstances do not show that version to be false. Here, the circumstances not only fail to show Ms. Benefield's versions to be false, but in many ways corroborates her account. The state has failed to present any evidence that directly contradicts Ms. Benefield's account of the events inside her bedroom on the day in question. Therefore, in accordance with the principles outlined in Fowler and the long line of cases it synthesizes, it is this court's duty to grant a judgment of acquittal. This applies not only to the charged offense, but also to any lesser included offenses not supported by the evidence. The state's failure to contradict Ms. Benefield's account left no room for a jury to legitimately find guilty on any charges related to this incident. Wherefore, Ms. Benefield praised the court grant her motion for judgment of acquittal. Now, even bigger, I think, than that last filing is this new motion to interview jurors. It says on July 30th, 2024, the jury rendered its verdict. Evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. The alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair and impartial jury and subjects the verdict to legal challenge. During jury deliberations, a YouTube user, That Hoodie Guy, posted comments on the Law and Crime Network's YouTube live stream of the verdict watch. These comments contained real time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. The comments posted on July 30th reveal at 10:20 p.m., 10 minutes before the parties were notified a verdict had been reached, That Hoodie Guy posted comments stating verdict incoming. At 10:25 p.m., That Hoodie Guy posted a comment stating per sources 5-1 guilty with the man stuck on not guilty or manslaughter. At 10:27 p.m., That Hoodie Guy posted a comment stating my sister snuck a flip phone in. At 10:28, That Hoodie Guy posted comments stating my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. At 10:30 p.m., a mere 2 minutes after That Hoodie Guy posted that the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter. The timing and specifics of these comments, followed by corresponding jury actions, strongly suggest that That Hoodie Guy's information originated from within the jury room during active deliberations. This represents a breach of the jury's sworn duty and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. This alleged misconduct raises serious concerns about the integrity of the jury deliberations and the reliability of the verdict. Specifically, it raises questions about a juror smuggling an electronic device into deliberations, which is not permitted in the jury room. B, real time communication of confidential jury deliberations with non jury members. C, influences external to the evidence presented during the trial may have influenced the verdict. D, access to unauthorized materials affecting the verdict. E, the overall integrity of the fact finding process being compromised. The prompt removal of these comments from the verdict watch on the Law and Crime Network's YouTube channel live stream further underscores the seriousness of this potential juror misconduct. In addition to the above, evidence has come to light indicating that the verdict may be subject to legal challenge due to Juror 15 being untruthful during jury selection by falsely representing that she had not been a victim of a crime, her son had been charged with a crime, and she had involvement with a child custody, domestic violence, abuse matters. Juror 15 completed a jury questionnaire under the penalties of perjury, which asked, have you or a member of your immediate family been victim of a crime? Juror 15 responded untruthfully to the question by omitting that she, number one, had been a victim of a crime, battery, touch or strike, domestic related, on February 20th, 2016, when her live in boyfriend intentionally slapped her in the face with an open hand 5 times. And number two, that her son had been charged with felony battery against his pregnant girlfriend on August 31st, 2014, for which Juror 15 was the bond depositor. They go through a lot of these filings by this juror where she's asking for an injunction. The response to this motion for an injunction alleges this juror also was physical at times. Juror 15's failure to reveal this information during jury selection amounts to juror misconduct and subjects the verdict to legal challenge, entitling Ms. Benefield to a new trial. This motion is filed within the 10-day period to address the urgent matter. Giving the nature of alleged misconduct, Ms. Benefield asserts there is reason to believe that the verdict is subject to legal challenge on multiple grounds, including, but not limited to, A, juror misconduct, B, introduction of prejudicial information, C, influences external to the evidence presented during trial that may have influenced the verdict, D, a violation of jury sequestration, E, violation of the defendant's 6th and 14th Amendment rights, F, jurors potentially receiving evidence outside of court proceedings to the detriment of the defendant's substantial rights. The integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. This court has both the authority and the responsibility to investigate this matter fully, including granting permission to interview all jurors who served on this case. They are asking the court to set a time and place for the interviews to be conducted in the presence of the court and the parties. They want to summons the jurors to appear at that time and place set for the interviews and grant any other relief this court deems just and proper under the circumstances. It's going to be interesting. I will keep an eye out for you guys and let you know if anything comes of this. Moving on to Alec Murdaugh. The South Carolina Supreme Court has agreed to hear his appeal after 5 justices signed off this week to take over the case. What could happen? Well, the Supreme Court here in South Carolina could overturn Judge Toll's January ruling that no new trial was warranted after allegations clerk of court Becky Hill tampered with the jury. Just a little recap, you all know this, but Murdaugh was convicted last year of killing his wife Maggie and their son Paul. This past January, Judge Toll heard from the jurors in the case where they were asked if they heard Becky Hill making any comments about Murdaugh. The first juror to testify said she heard Becky Hill say, "Watch his actions and watch him closely," before he took the stand in his own defense. The juror said these comments impacted her verdict, but ultimately, Judge Toll denied a new trial. In their filing, his defense team says the trial court abused its discretion when finding that the jury's verdict was not affected by Miss Hill's tampering, despite a juror's uncontradicted testimony that her verdict was affected. And the trial court erred when it held that deliberate jury tampering by a state official seeking a guilty verdict was harmless because, in its opinion, the correct verdict was rendered regardless. The Supreme Court will be hearing arguments from both sides before making their ruling. Murdaugh's attorney have 30 days to file their initial arguments. So I'll stay on top of it. If anything changes, I'll let you know. If there's any new filings or any new responses, we'll break those down for you. Just a reminder, later today, the trial against Robert Tellis is continuing. I'll be live streaming that. Come chat with us. We have a great group. It's always nice to watch a trial with other people where you can talk about what you're seeing in real time. So come hang out with us. We would love to have you. All right, that's it. I'll be back tomorrow morning with an update on day 2 in the Tellis trial. Until then, I hope you guys have a good rest of your day. We'll see you soon.